Short sale fraud. What are the terms of the short sale? You got to take a look at it. We've done a lot of short sales where sometimes the buyer is buying the property and cannot sell the property for up to 3 months sometimes. Typically it's 30 days. What are the terms of the short sale? One, is it an arm's length transaction? I have a lot of clients that come to my office sometimes and they'll say, I know who I want to buy the property from me. What's the relationship of this person that's buying it? It's my wife's brother's, cousin's, sister, and it doesn't have a last name. Can we do it? The answer is no. No. What's going to happen is you're going to negotiate the deal, you're going to get the approval letter, the buyer's going to buy the property, and it was not an arm's length transaction. We all signed it. And 90 years from now, because it's a fraud, there's no statute of limitation. The bank's going to find out, and we're cheating. If you're lying to the bank, you're lying to the federal government. We're all going to spend time in jail 90 years from now is what I typically tell my clients. So it is not worth it to get involved in helping a family member buy this property back to help facilitate the short sale so we can all make a couple $1,000s today and then spend the rest of our last 10 years in jail because we're lying. Arm's length transactions is critical, and do not allow family members as far extended as they are, because if they do ever find out, that'll be the last real estate transaction you do. Sales price must be based on fair market value. Take a look at the approval letter. It's sometimes in there and it's sometimes not. The lenders are sometimes asking, are there no other agreements that have not been disclosed? And I wrote a C buyer, which I'm going to get to with my next slide. And then the fourth issue that I'm seeing is use of C funds rather than B's funds. And most title companies know not to do that. I'm going to get to that with my next slide. Here's a picture now with the short sale. I wrote A to B, B to C. Show of hands. Does anybody know what I'm talking about when I say A, B, and C? Yes. 1, 2. I thought I'd get at least half the room. How many people do not know what A to B to C is? The other half should be going up. So you guys aren't participating. That's fine. It is getting warm in here, isn't it? Yeah. I thought it was just me. So someone's going to help out with air conditioning, right? Yeah. Okay. Short sale. The A to B to C transaction. As realtors, the title companies have to have seen this, but as realtors and brokers, you need to be aware of the fact that A to B to C transactions are where the person B is coming in as the investor and basically looking to sell it to C and reap that, that profit. The example here would be if we have a mortgage balance of $110,000 where we're negotiating with the short sale lender. $110,000 mortgage, and you negotiate with the bank and they're going to accept $50,000 in the short sale, knowing that the property is worth $127,000. So what's happening is A is selling it to B, the investor, for $50,000, and B is going to go sell it to C, the end user, for $127,000, a gross profit of $77,000. When we backtrack and we get the realtors to sign on, the buyers and the sellers and everybody to sign on that there are, number 3 up there, no other agreements that have been disclosed, we're lying. And it's a matter of time for the bank to catch up on that, because if they do their research, they're going to see 2 sales that happened that day, and somebody walked away with $70,000. You can't hide it. A potential fraud. Read the terms and make sure you know what you're doing. Short sale fraud. Parties. The parties include the buyer, borrower, seller, real estate brokers, the title agents, and the transaction facilitators, which I'm going to get to in the next slide. Fraud. Foreclosure-related rescue services. It's been a hot topic, and we've all heard about this for the last several years, about mom and pop companies, no licenses, that set up shop years ago trying to help people with their loan modifications, and they'll charge whatever they charge, $1,000 up front, monthly fees, and they've got thousands of clients. And what is their expertise and their knowledge and their license? And it's really none. They've got no training, no expertise. They're just created a service to basically say, we're the experts and we can do X, Y, and Z. but they don't have the license supporting it. Foreclosure-related rescue services. What happened was the federal government basically set guidelines to basically shut all of those shops down and make sure that there's only certain licenses and certain people that can provide these services to distressed public. With any service relating to promising assistance, what foreclosure-related rescue services relate to are two things: stopping, avoiding, or delaying foreclosure proceedings, if you promise to provide that service, or curing a default to a residential loan. If you're helping somebody perform a loan modification. The fraud. Foreclosure rescue consultant must, 1, provide the service without provide the service with a written agreement for foreclosure-related service. So you have to put a written agreement in place. And the second one is you may not solicit, charge, receive, or attempt to collect payments before contemplating performing all of the services contained in the written agreement. So the point being, and I just noticed provide service without, it's actually with a written agreement, if you can see that on the slide. Must be in writing, and you cannot collect any fees until after you perform the task in the written agreement. If you're collecting any fees up front, you're in violation of the foreclosure-related rescue services, and your office can be shut down. For those people that you know that are out there performing these services and saying they can do X, Y, and Z, and promising services and collecting monthly fees or upfront fees, are in violation of this rule and maybe jeopardizing their so-called practice. Another major issue that's out there is unauthorized practice of law as it relates to all of the real estate transactions, particularly in the short sales. I spent a lot of time on trying to find a really good definition to summarize it, or what are the components. And I found under Florida versus Sperry, and I'm just going to read this paragraph real quick. The unauthorized practice of law is the giving of advice and performing a service that affects important rights of a person under the law, and if the reasonable protection of the rights and the property of those advised are served, requires that the person giving such advice possess legal skills and knowledge of the law greater than that possessed by the average citizen, then the giving of such advice and the performance of such services constitutes the unauthorized practice of law. I'm going to try to summarize that real quick. If you practice law on yourself, it's legal. You can do and give yourself legal advice, but if you start giving advice to others, and that's where in this paragraph it says performing the services as it affects the rights of a person, someone other than you. The other components are if the advice possesses legal skill and knowledge of the law greater than that possessed by you, and you have to look at what does your license cover you for. I've done other education as it relates to what can a realtor do, what can't a realtor do. We know that outside of the short sale market, realtors typically filled in the FAR bar contracts or whatever contracts that their brokers give them, and your scope and your license only allows you to pretty much fill in the blanks. To actually be marking up the contracts and writing up terms, for the parties would be a practice of law, as you're now interpreting and rewriting the contracts, and if there's any misinterpretation with intent, that could be something that can be a violation against you and your license. And you're also stepping outside of the boundaries of, for example, as a realtor, your realtor's license. The unauthorized practice of law, exceptions with it are the non-lawyer title agent can draw legal documents to fulfill the conditions of a title insurance commitment. So we know that a title company can draw the deeds, quitclaim deeds, and any other documents as it relates to title insurance. So there are legal documents that can be drawn up by title agents. Real estate licenses may contract for the sale of real estate for others, while non-licenses may not. You already know that a non-licensed cannot participate in the buying and selling of other people's real estate. That's why we've got our licenses so we can participate in helping people with the contracts of their real estate deeds. Real estate brokers are not allowed to prepare other documents that finalize the transfer of real estate, such as deeds and mortgages. I emphasize on real estate brokers, but it really touches upon, and I've seen it many times, and I'm hoping you guys out there haven't, but we know that there's people out there that are actually telling homeowners to sign over their deeds of their property to whomever, and they're then going to facilitate the deal. It's usually like the B investor, and then you negotiate a short sale, but the deed's now in somebody else's hand. But who's preparing all these documents? It's typically between the investors, the realtors that are getting involved, and everything else. But those actually touch upon unlicensed practice of law. If you're actually now creating deeds, recording deeds, and doing things that affect the particular subject property. I somehow did it, I think.
I am so proud of you.
I just want to thank you all very much for this opportunity. I'm a proud member of the Women's Council of Realtors. I had the privilege of presenting a couple months ago in Boca Raton at their chapter. And again, if I can be of any further assistance, please don't hesitate to call me or email me. I'm here to help and hopefully branch out my services up here as well. Thank you all very much.
Thank you.